Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching a miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
with Terrance Ketchel presiding.
Good morning, Your Honor.
Say it again, so I can get it right.
Misc.
Start with, when you start with.
Thank you, Your Honor. I think I only have one case on the docket today. Garcia Perez, State of Florida versus Edwin Garcia Perez, case number 2022 CF 1815. Your Honor, it was set for today because I didn't have any discovery last time we were in court. I did get the discovery that is in the state's possession, but we discovered yesterday that we're missing a bunch of critical videos. So we're going to try and resolve that. Ask to move the case to, well, whenever you're
On
on.
a regular pretrial?
That sounds perfect.
Okay. So August 14th?
Wonderful.
August 14th.
Thank you very much, Your Honor. I have nothing further.
Thank you.
Have a great day.
Mr. Conner?
Good morning, Your Honor.
Good morning.
And I have two cases on today's docket. The first one is Joseph Kinsworthy. He's present before the court, case number 22 CF 907-779. Judge, after speaking with the state attorney this morning, we're going to need to continue this case. We were close to a resolution, but it's my understanding the state's got some new evidence they want to review that may change the charges or add additional charges in this case. In either event, we're not prepared to resolve the case today. Is that fair?
That's correct.
This is a violation, correct?
It is, Your Honor.
And has there been a plea yet?
There should have been a denial entered, Your Honor. If not, we entered.
I'm sure there is. We just continue to keep them on the docket.
Okay, usually.
Well, there was an
Evidentiary, it's already been entered. We've done it before, but I don't mind whatever the law is.
Yes, sir, but when they file their denial, they still have to appear.
Okay.
In addition, I actually emailed the office, your office about that yesterday. It was an issue I had where I'm not going to be here next week and enter a denial on the VOP, and I was told we need to do a continuance motion. And my issue with that is I'm not continuing the arraignment. I've entered a denial on the arraignment, so I don't know why that shouldn't be enough to have it come off the docket. And I asked Eileen to see if we could get an answer on that, because there's no sense that we enter a denial, why it shouldn't automatically come off the docket.
And that has not been the issue in the past. I don't know if the clerk's office has a new issue. In the past, when you've entered just like a not guilty plea, it just goes to the next available docket for VOP. But this may be something new that the clerk's office has.
That's what our understanding was as well.
Well, I understand that. Is this a change? They're saying it's a change.
We still keep it on the VOP docket, regardless of the denial on the VOP being entered. Now, if y'all want to do something different, that's fine.
I guess the
But
first
I'm
one.
not the one to make that change. You are.
Sir, I agree with that. Why don't we do this? I want to, rather than just kind of launch out, because I'm hearing different things. You're saying one thing, the clerk's saying another. I'm going to go talk to Judge Brown, see how he's doing it, try and have some consistency, so
Yes, sir.
at least everybody knows what they're doing, so. And, you know.
I don't think it's unilateral on your docket, Judge, because I've got the same thing going down in Judge Mason right now on a VOP denial I had entered, and I'm still on the docket, and I'm here. But, so, either way, I don't think it's just your courtroom. Yes, sir.
Well, no, I understand. No, I'm not saying that anybody's doing anything wrong. I just want to try and get some consistency so everybody's clear about it.
Yes, sir.
And you're right, we're doing the same thing we've got county judges as well.
Yes, sir.
So,
Okay. For today,
but
Judge.
today, Has there been a denial?
Yes, sir.
If there's been a denial entered, we'll come back. You want to come back in a month or so? Ms. Ladies?
Probably sooner.
17th, 22nd?
Let's do the 17th. Sooner rather than later. I just need to get with Mr. Losco on some different situations,
We can do it
probably.
next July 18th.
We'll go probably in August, Judge, by the time I get to
Okay,
schedule.
August 17th.
Yes, sir.
We'll come back August 17th.
August 17th.
Thank you.
All right, Judge, thank you. Your Honor, the next case I have is Anthony Knudsen. And this is a new law offense, so I know we're here on VOP docket. He is on my calendar. No, is he on your calendar?
He is.
Judge, I've already entered a not guilty plea on that. We're going to need a,
He's come here under plea. Somebody must have.
Let me just look at the last minute sheet on June 12th.
I think I tried to probably fast track this
Defense asked
case.
for this morning at 9, so we put it on this morning at 9.
I think there might be some, you might thought maybe you get plea coordinated, but it hasn't.
That is, we've done some depositions, Judge, but unfortunately we were unable to depose everybody. I'd probably like to just put that, if I can put it on your 17th court
Or
date.
pre-trial?
When's that, Judge?
Well, the pre-trial, pre-trial is 14. Yes, sir, a regular pre, is this not a BOP, it's a regular case?
That's correct, Your Honor.
Okay, so let's just put on the pre-trial.
That's
14th.
fine.
Well,
8/14?
excuse me, 16th, which is the ending. August 16th, right?
My client's not an inmate, Judge.
Okay, oh, that's right. Okay, so 14th, August 14th.
Okay. Your Honor, that's all I have, but Mr. Patel has a case that he asked her to handle this morning.
Okay.
Robert Homco, Homco. It's my understanding this is a request for continuance. He's still waiting some discovery in this file. I believe it's the first.
Cancellation was in.
Okay.
I was prepping it yesterday, but I pulled out, just to make sure.
No, sir, the bond hearing was canceled.
Well, that's what we have to do.
Oh, I showed that this is a VOP arraignment and a bond hearing, but the bond hearing was canceled.
Okay, I just have this as bonding, so you both of them. So are we continuing the, for lack of a better term, VOP arraignment?
Yes, sir.
Judge.
Well, I assume there's been a denial entered on
I
that.
think there's been a denial entered,
Okay.
so I don't think we have to continue.
And when does he want to continue it until?
Judge, he just asked to continue it to next month, so maybe your 17th docket.
Okay, we'll continue until August 17th. And there has been a denial entered, that's correct? Okay. And the bond hearing itself, that's been canceled, this is just tracking the regular case. So
That's my understanding.
we're not having a bond hearing on the 17th, we're just having a VOP hearing.
Got it. And all these are 9 a.m., correct?
Never mind, Your Honor, I thought he wasn't an inmate, he is an inmate. So the 17th is the correct date.
He is an inmate, Mr.
I do not have him listed as an inmate.
Now,
Oh,
my
no,
notes
posted
reflect
bond,
that
I
he
apologize.
works, sorry, I didn't mean to walk on you.
He posted bond, Judge, he's not an inmate.
Oh, he's not.
I apologize.
Well, I'm saying.
Reason for the cancellation of the bond hearing.
That's all right, we're good. Okay, anything else to cover, anybody else?
That's all I got, Judge. Thanks.
Mr. Shaw?
Good morning, Judge.
Good morning.
First case I have is Daniel Maya Lemus. Judge, that appears to be a PTI. We've changed some of the terms this morning. I need to pass it for a few minutes so I can take him outside easier and go through it, make sure he understands everything.
Okay.
The next case is Austin Bazette. Austin, come on up. Judge Tim Shaw for Austin Bazette. This is case number 23 CF 329. We have, my client has signed a PTI agreement. The state has as well. Does the court need to take a look at that before we hand it to the probation officer?
No, it's been agreed to by the state.
Okay. Thank you, Judge.
Thank you.
Do you have control of it to be filed, or we'll just rely on?
He's handing it to him right now. There's a place for the probation officer to sign as well, so I think they wanted us to announce it to the court before they signed off on it. Judge, and lastly, I have Gary Fagan, F-A-G-A-N, 22 CF 2129. We have reached an agreement on that case for a plea to a misdemeanor. Mr. Fagan was ill this morning. He contacted my office early and indicated he wasn't going to be able to make it to court. I assume that, I don't want to assume, I would ask the court to accept a written plea since it's to a misdemeanor. Would the court be inclined to do that so we can get it filed right away?
That's correct, Your Honor. It's going to be to misdemeanor charges.
It's for a misdemeanor. We will set, we ought to do a control date.
Perfect.
That in between. Is this a VOP, so it should be on the regular docket?
No, no,
We'll
Judge.
just put it on, for an August 14th, just regular pretrial, but assuming it will be taken off this result.
Thank you, Judge. And I'll recall Mr. Miles in just a
Yeah,
minute.
and when you come back in sometime, I'm like paying attention, kind of wave at me, we'll get you right back.
I'll do it. Thanks, Judge.
Who came in first? Mr. Keach, Mr. LaPella, who gets it?
Go ahead, Sean.
We're gonna fight each other.
We'll let Mr. LaPella
Okay.
go on recess. Somebody else. I'll be fast.
Sean Lupella for David Cannon, 20 CF 1178 and 21 CF 662. I don't believe Mr. Cannon is able to make it. We sent him for an early plea to try to be expeditious about resolving the case, but unfortunately he's having some phone trouble and car trouble. He does have another court date on the 18th already, so if we could just pass it to the 18th, I'm confident we can get it done that day.
And Your Honor, the state's okay with that because I believe that Mr. Lupella filed a written denial and this is the first hearing on this case. So if we.
Okay, so you want to come back in, we could do it next week, July 18th, is that too soon?
I'd like to set it for the 18th. It's already set for that date on the other case. So. and
Yes, he
that-
has 2 VOP cases.
And he's got notice of that date, so we're good there.
I think that's fine with the state, Your Honor. This is a case where we've already worked out reinstatement, so I think that'll be fine.
Okay, we'll continue this case until July.
Thank you, Your Honor. That's all I have. I can excuse.
Thank you. Mr. Keach?
Karen Florence.
Good morning, Your Honor. This is State of Florida. This is Karen Flores, F-L-O-R-E-S, 22 CF 1539 and 22 CF 1562. For the court on a motion to reinstate his bond, Your Honor. As set forth in the motion, he was originally granted a bond in 22 CF 1539 in the aggregate amount of $24,000, and in 22 CF 1562, he was granted a bond of $1,000, which he posted. Subsequent to that, he was arrested on 2 new law violations in 22 CF 2481 and 22 CF 2485, where he's represented by Mr. Gates with the Public Defender's Office. That resulted in his bond being revoked. He's been incarcerated since September, and until recently was in yellow, correct? He asserts that he understands his conditions of pretrial release better now, that if he would be reinstated, that he would consent to a GPS monitor, and he has the opportunity to be gainfully employed as a roofer if released. I do recognize that the condition is that he does not violate his bond against charges, but we're hopeful based on the time that he has been incarcerated due to the revocation of his bond and the opportunities he has at release that the court would allow us to reinstate his bonds.
I'm just trying to get the sequence of what happened.
May I? Judge, what happened was he was arrested on June 12, 2022 for fentanyl trafficking, in possession of a controlled substance and burglary of an unoccupied structure. Then some 2 months later, he made a decision to go ahead and get picked up on the charges that Mr. Gates represents him on, which is the battery on an officer or firefighter, and then also having controlled substances on him at that time. Now, I understand that Mr. Mr. Quiche is saying that he now understands the terms of his, pretrial release better. How hard could it be? Don't pick up new law violations, don't do drugs, don't possess drugs, and yet he chose to continue doing that while he was actively facing not just trafficking charges, but trafficking charges for fentanyl, which is a scourge on this nation and causing deaths every single day in Okaloosa County. So it's the state's position that he should remain right where he is, because that's where he needs to be for the safety of the public.
Judge, we just would suggest that in the trafficking case, we've conducted most of those depositions, other than the law enforcement officers that we have set for the 14th of this month, so on Friday. I believe that the depositions have revealed that there was no burglary, there was no intent to commit a crime when he entered the property. Certainly, there are some evidentiary issues from our point of view in the trafficking case. A key witness is out of state and unavailable, which will now require us to go travel to Louisiana after we just received her current address, where we had intended to schedule her for this week. Another officer is unavailable, so there's delay on the part of law enforcement in moving this case forward. And he is innocent until proven guilty.
Delay because of what?
Well, one witness has moved. We had a bad address. One of the officers for
You indicated that the state was delayed.
well, I'm saying
Witnesses, right?
witnesses, correct. But there's also a law enforcement officer who's unavailable for no reason provided.
Well, it looks like y'all are making a lot of progress. Let's get this thing set for a trial. Of course, denying the motion on the bond reinstatement. Let's get this thing set for a trial. Let's move. If you got a contested issue, let's go to trial. And that's what we need to do with these cases.
Yes, sir.
These are very serious charges. I agree with the state. It's fentanyl charges, serious there. Actually, when I looked at it, I don't know all the circumstances at the bond hearing, so I can't say, I'm not suggesting it's too low, but I did note it was lower than most of them. And so, of course, denied.
Thank you.
Thank you.
For tracking purposes, the court will place us on the August 16th.
Yes. August 16th.
In Mr. Gates' case, is that, I think,
I believe they're already set on that date. I'm checking each one now.
Sure. I would think so, but it's good to make sure we get them on for sure.
They're already set.
Okay, so August 16th. Thank you.
Judge, that's all I have. Maybe a question.
Ms. Dudley?
I have one case on the docket. I'm Justin Kekahuna in 21 CF 3253. We were set today, we're working on getting proof of the completion of the PTI. He has paid costs, we have shown proof of the death course. There was an issue yesterday about getting the money to the victim. So he's given it to our office, we're going to write a check and send it to the victim so we can get their first day in August as a status. And I'm hoping by that time we can have proof, give it to the state, and the state can dismiss it at that point.
That's fine. We can, he's out, so if he was in, I said I was trying to do it on the 18th, but we'll just do it in August, so we'll give you plenty of time to get it done. We'll come back, continue to August 17th.
Yes, sir.
What do I remember something? And that one and the 21st. We'll do it on the 17th.
That's all I have, Aaron. Thank you.
Thank you. Sorry, I'm not stacking.
On the 17th, I have 4 scheduled thus far. And then what was your number, Penny?
22nd, August 22nd.
I have 1.
Okay, so there's one. Mr. Shaw, could you re-announce, please?
Thank you, Your Honor. I'd like to recall State of Florida versus Daniel Antonio Amaya Lemus, 22 CF 2241. I have read through the modified or amended pretrial intervention agreement with my client. The state has signed it, my client has signed it as well. We'll hand it to probation and get that taken care of.
Very good. Thank you very much.
Thank you, Your Honor. That's all I have.
Appreciate it. Yeah, want to do the unrepresented, get those done. Dayton Bragg. Was the state announced?
What was the name, Judge?
Bragg, Dayton Bragg. 22 CF 1893. And for all of y'all, I'm going to call that there's several other individuals that are here without attorneys on the violation of probation. This is similar to an arraignment. We're here primarily to get plea. You do have a right, if you cannot afford one, to have an attorney. So I'm going to ask every one of you, do you want to have an attorney? Some of you may have spoken with the state. And that's between you and the state. If you feel like you want to resolve something today, that's fine, but you're certainly not compelled to. As a matter of fact, I'll be asking you a lot of questions to make sure you understand what you're doing. But we're here primarily to enter a plea. So I'm just letting everybody know so we can be as efficient as possible. State?
Yes, Your Honor. This is Mr. Dayton Bragg, case number 22 CF 1893. He's here on a violation of probation. The state's offer, if you would like to resolve this today, is bars to bed Keaton and impose the original terms of his probation. So it would be a modification today, Judge.
You do have a right to have an attorney appointed. You wish to have an attorney appointed, and they'll convey, you can discuss that.
Yes, sir.
Offer. Court will appoint the public defender. I'm going to go ahead and enter a denial on your behalf. That will preserve your rights. Make sure and get contact information. We'll come back on August 17th for the next hearing on this case. Your attorney in the interim.
Yes, Your Honor, definitely with me, if Mr. Bragg can have a seat, I'm going to have to fill out some information before he leaves. So make sure to fill the application out before he leaves.
And thank you, and I'll repeat that for everybody else who's not an attorney, who does not have an attorney. You'll have to fill out the form in order to qualify, make sure you qualify. So you want to do we'll do the out of custody, no attorneys, and then we'll come back with the in custody. You want to do that?
Or I have to wait.
Okay, well, let's do a Samuel Green. State when they come out.
Yeah, just so the court's aware, the public defender's office is appointed to Mr. Green's new law violation. So I can actually, if the court wants to just inquire, I'm sure Mr. Green would like me to represent him on the VOPs.
Mr. Green, do you wish to have Mr. Gates
Yes, sir.
appointed to a corporal appointed public defender?
Yes, Your Honor, and we have an agreement reached, but the state's asked to bring Mr. Green back this afternoon. They want to get the score sheet printed so I can go over that with Mr. Green. But the plea agreement is going to be 12-1 to cover all cases before the court.
1:30?
1:30.
And we'll bring me come back at 1:30.
Justin Jones.
Mr. Jones, I'll send this issue back. You'll come to the lawyer.
Judge, this is Mr. Justin Jones, case number 22 CF 1688. He's charged with violation of probation. If you'd like to resolve this today, the state would accept 6 months Okaloosa County Jail, revoke and terminate his probation.
Okay, Mr. Jones, you do have a right with these new charges, violation of probation. You have the right to have an attorney appointed. You wish to have an attorney appointed?
Yes, sir.
The court will appoint public defender. You have to fill out a form and whatnot.
I did sometime last week, sir.
I'm sorry, that's good, okay. So the court's gonna go ahead and enter a denial on your behalf. That will just preserve your right. You can talk with your attorney. That offer will be out there. You need to discuss it with them further, okay? I mean, you can accept it today. Generally, when there's a jail sentence, generally, it makes sense to talk with your attorney before you. But if you want to accept that offer from the state today, More than willing to do that.
I thought so, the attorney.
You want to talk to the attorney? Very good. The court will appoint the public defender, enter denial, and we'll come back on August 17th. Okay? Thank you.
Mr. Morrow will be the public defender?
No, Mr. Gates, Mr. Morrow is leaving our office at the end of the month, so they're gonna go back to Mr. McGee and
Where are you
myself.
going?
Back to Escambia, Your Honor.
But, I'm sure that's not, it's not your choice.
I can explain off the record in the court today, Your Honor.
I'm just kidding, yeah, I understand you all move around, but. Jerry Mays. To the stage now.
Yes, Your Honor. I'm covering for Ms. Basso this morning. This is 21 CF 1932. The notes that I have for Ms. Basso indicate, I'm sorry. That the recommendation is to impose the 36-month suspended Department of Corrections.
Very good. So, sir, you do have a right to the attorney to say you've got a right to have an attorney appointed if it's in violation. You wish to have an attorney appointed.
Yes.
The court will appoint the public defender. The court will enter a denial on your behalf, so you can preserve your rights. You'll come back on August 17th at 9 a.m.
And who is this, Your Honor?
This is Jerry Mays, 21 CF
That's
1930.
gonna be with Mr. Medina, Your Honor.
Okay? Very good. Any questions?
Yes, sir.
I think you just have that application.
Please.
You can address the court. If you do, I'm going to swear you in. If your attorney was sitting there, he'd be telling you not to do that.
Yes, sir.
If you want to talk to the court,
I do.
you have a right to do that. You want to talk to the court?
Yes, sir. Please.
Raise your right hand. You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes,
You
sir.
understand that this is being recorded?
Yes, sir.
Anything you say can and will be used against you in a court of law?
Yes, sir.
May you address the court?
First, I would like to apologize to you, Your Honor, the state, and on my charges that I just picked up. It was Father's Day. I've been on probation for 19 months, house arrest 6 months with the ankle monitor. I had friends down from Tennessee. They were at the beach. I know I can't get in the ocean. I didn't get in the ocean. It started raining. We went and sat beside the pool. I had my monitor with me. I stuck my backpack directly behind me. All I did was put my feet in the pool water. I
This is
didn't
the kind of stuff you
understand.
need to be talking with your attorney about.
I know. I just wanted to let you and the state know that I apologize for what I did. I didn't have any clue that I was violating my probation, and I do apologize to the state.
Okay. Thank you.
Thank you,
Come
sir.
back on the 17th, okay? Talk with your attorney in the interim.
Yes, sir.
Okay, I think that's all of our, you got an attorney?
Could I, we have a max inmate,
Sure.
Anthony Miles, who is represented by Mr. Cobb, I believe, and the state is,
Yeah, there was a, why don't we bring him out?
oh, yes,
Who's handling this for the state?
Your Honor, that's me. I'm covering.
Why don't you now, because there's a, this is an element here, and there was a motion to continue.
Correct.
which kind of a little-
I did see that.
And I had heard that Mr. Cobb had filed, that he had a positive COVID result that was filed in Brown's cases yesterday. I don't know about that.
I can find that
Go ahead and
information.
announce the case.
Your Honor, the case that Mr. Miles has on the docket this morning looks like 20 CF 1370. I am covering for Ms. Basso this morning. It is my understanding from my notes from Ms. Basso that there was a Nelson hearing scheduled. I did see in my notes from Ms. Basso indicate that Mr. Cobb filed a motion to continue. I am unsure what the content of that is. I didn't have a chance to look at the actual motion.
Well, further, what I just informed the state is that we got word that Mr. Cobb had, in a case from yesterday, had filed that he was positive for COVID. I mean, obviously, we have to deal with that. You need to just pass it on to Mr. Cobb, that the filing of a motion for continuance does not mean continuance.
Yes, sir, I will do that.
There's an order that has to be filed before there would be continuance.
Yes, sir.
But in this case, because he's ill, you know, I mean, we have to, not much we can do about that. So, there was a motion for continuance, and the motion indicated that there was a conflict. We've got, what do we have next week? On the 18th.
I showed you have 30 cases set in the morning, then you have your felony plea date of 23, then in the afternoon, you're up to 7 cases.
Are you still wanting to have enough in here?
Yes.
Okay, why don't we come back on the 18th in the morning?
And just to let the court know, I think Ms. Basso might still be out on the 18th, and Ms. Bergman might be covering, but I will let Ms. Bergman know so that
Somebody got to let Mr. Cobb know too.
I will, Judge. I will let Ms. Bergman know, and I'll email Mr. Cobb as well.
Okay, we want to get these Nelson hearings.
It does need to be heard, yes, Your Honor, and I don't want
Okay.
Delay it,
In case
so.
we move forward, if it's not with this attorney, you need to do somebody else, then you need to have your day to argue your case, okay?
You said the 18th? You said the 18th?
18th, that's next week. July 18th at 9 a.m. Mr. Harper, you want to?
Judge, all of mine are in custody. I'm not certain if you want to clear out the rest of the courtroom or.
In which case, you want to do your next up, you want to do any of your out of,
I'm not ready this time for my out of custody, Your Honor.
you are ready?
Not ready, Your Honor.
Okay. Mr. Medina?
Your Honor, my only out of custody that I'm aware of is a gentleman who requires an interpreter. I've spoken with the interpreter, but she's in 2 courtrooms. She's next door in 3B. So as soon as she comes out,
Just kind of wave at me, because I may know she comes, I may not. So let's
Yes.
go ahead and we'll proceed then, Mr. Harper.
Mr. Harper, we're going to do the emails first.
okay.
Which case is the first one?
I'm not.
Sarah Browder.
Okay, got it.
Sarah Browder.
Judge, this is Sarah Browder before the court on 22 CF 2882. Judge, at this time, we're not able to come to an agreement. I'd ask to set this on the August pretrial.
Is this a VOD or just a?
This is a new law, Judge. I was hoping that we could, I think we're just differing.
We're good. August 16th, convened August 16th at 9 a.m.
Patricia Davis.
Next is Patricia Davis. She's number 23 on the docket. She's before the court on 20 CF 1186, 21 CF 437, and 22 CF 1502. Judge, I think that we're very close to an agreement on this case. I think that the state needs to confirm with the victim as to our proposed counteroffer. If that's suitable to them, then we can resolve this. But we would ask to set this for the August 14th pretrial. It should be a clear trial. That's applicable.
With the resolution, what is the anticipated resolution? Would it require continued incarceration? The purpose of my question is, if it would result in her being released, was trying to get her done next week. But if they can't, that was done. But if it's not going to, if the resolution won't result in her release, doesn't matter, we'll come back and
Your Honor, just to let you know, that's what we are working on, and I do need to.
You're working on something that would result in her release?
I'm working on determining which option I'm gonna pursue. So I do need to meet with them, and I'm going to try to meet with them in person between now and August 16th, so.
Full disclosure.
So we're not far enough along.
Judge, full disclosure, she does score out. The anticipated resolution is either supervision or time served.
Right.
So
we'll come back August 17th.
Thank you. William Bentley?
what was the date, Judge? August?
August 17th. That's the next miscellaneous. You want to do the regular pre-trial?
Yes, sir.
Okay, that would be August 16th.
Okay. Thank you, Judge. This is Mr. Bentley. Judge, he's before the court on 23 CF 624. Judge, we're going to ask to set this for the August pretrial as well.
I've got this listed as a status.
Yes, Judge, what we had hoped to do, the victim in this case had requested charges be dropped, and I was hoping that the state would, in essence, take that into account and possibly dismiss it. The state's not willing to do that at this point, so we'll move this to the August pretrial for a plea or trial that cycle. I anticipate a resolution one way. This case will be resolved next month.
Your Honor, I think that this one is one we might be able to leave on the 18th. I should be able to speak with this victim this week. She's already called and set up a time.
That works out great, Judge.
So July 18th?
Yes.
So we'll continue this to July 18th at 9 a.m.
Donnie Bray?
You want me to leave it as a status? Or do
Yes,
you
ma'am,
want
that's
me to-
fine, yeah.
Okay.
So we're sign the date, 7. Judge Rudy Harper on behalf of Donnie Bray, he's before the court on 23 CF 787 and 23 CF 288. This will be a plea, he'll enter a plea of no contest. He'll enter a plea of a lesser included offense of sale, manufacture, deliver as 23 CF 787 count 1, which is a trafficking charge. All other counts as charged. He'll be adjudicated guilty, placed on 3 years probation, concurrent on all the felony counts. $615 in court costs, $150 cost of defense, cost of supervision, attending completed substance abuse evaluation, and any recommended treatments. There will be a 11 months and 29 days of probation concurrent on the 23 CF 787 count 2 and 23 CF 288 counts. Sorry, I wrote something weird. Count 2. Credit for time served in 23 CF 288 counts 3 and 4. Basically, on the first degree misdemeanors, there'll be a year of probation concurrent. On the second degree misdemeanors, there'll be credit for time served. There will be no action on the FTA. If I may approach.
Your Honor, can I approach Mr. Harper just so the court knows?
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Okay, and the score sheet, is that not down for departures?
It is not, Your Honor.
And is the defense okay with the?
Yes, Judge.
So, Mr. Bray, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide is course of truth, nothing but the
Yes, Your Honor.
So you heard your attorney state the terms of your plea agreement. I see those same terms are contained in the written plea agreement that you signed. Have you read this plea agreement closely?
Yes, Your Honor.
And have you gone over it in detail with your attorney, make sure you have all your legal questions answered about the plea?
Yes, Your Honor.
You understand that by entering this plea, importantly, you're waiving the right to go to a trial and force the state to prove their case and all that. This will be a final resolution of your case. Do you understand that?
Yes, Your Honor.
And you believe this is in your best interest?
Yes, Your Honor.
Now, we threaten the court to get you to enter into this plea?
No.
And the state's in agreement with the plea?
Yes, Your Honor, and the state also spoke with Okaloosa County Sheriff's Office about this, and the Sheriff's Office agreed with this resolution.
Very good. Okay, so Mr. Gray, based upon that testimony, the court will accept your plea agreement and your plea to a lesser included offense of the sale, manufacture, and delivery as to 23 CF 787, count 1, and all other counts as charged will be an adjudication of guilt. You'll be sentenced to 3 years probation, concurrent on all felony counts, and you'll be sentenced to 11 months, 29 days on the 2 first-degree misdemeanors, right?
Yes, sir.
And then credit for time served on second-degree misdemeanors.
Yes, sir.
Okay, so you've got 2 different categories of cases, but all these probations will be served concurrently. There'll be no action on the FDA. Importantly, you do, during the terms of the probation, it needs to be immediate. You need to go ahead and have a substance abuse evaluation, follow through with any recommended treatment. You understand that?
Yes, sir.
Now, we didn't put in here, which we often do, that he needs to do that, within 30 or 60 days. Is that to say if there's something that's needed? Just want to make sure we're doing it purposefully.
Judge, I'm fine with that language. I'm complying with getting the evaluation within 30 and treatment within 60.
Yes, Your Honor, indeed. I'm sorry the time limits were not listed in there, but yes, the normal requirement is for them to get the evaluation within 30 and then start any recommended treatment within 60.
I'm just going to go ahead and ask you to
Yes, sir.
kind of put those in there and make sure to let him finish it. That's an important component. Technically, you have until, if you have a 3-year probation, you have the full 3 years to complete that. That doesn't really make sense. You're waiting all the way to the end, and more likely to have an issue or something like that. So we want to say, hey, jump on this thing, get the evaluation, and then you'll have plenty of time to follow through.
Yes, Your Honor.
So we're adding evaluation in 30 days, treatment within 60 days. You get initial
And you'll be able to get out today and make sure and get over the probation.
Yes, Your Honor.
Okay?
Yes, Your Honor.
Thank you very much.
Thank you, Your Honor.
Mr. Gray? Next I have is Howard.
Judge, this is Tremont Coward. He is before the court in 20 CF 2490, 20 CF 299, and 23 CF 52. Judge, this is a motion to reduce bond. Basically, he has no bond in the violations of probation. His substantive offense, which is the sole basis for the violations of probation, was a fleeing and eluding. My client was not caught on scene, identified as the driver. They found some circumstantial evidence that led them to believe that he was the driver in question, but there is no real witness, so to speak, with respect to Mr. Coward being present in the vehicle at the time that these allegations were alleged to have occurred. In that, we believe that this is entirely circumstantial. We are asking for a bond with respect to the violations of probation. He has not had any other violations. Up to this point, I believe that he did complete Keaton, and he was working pursuant to the terms of aftercare at Keaton, and was doing by all accounts well. So we are asking for a reasonable cash or professional bond on the violations of probation.
State.
Yes, Your Honor. So in this case, he is on probation, and one of the charges that he is on probation for is also a fleeing and eluding. He's alleged to have violated his probation by picking up a new fleeing and eluding. And Your Honor, if and looking at the facts, I believe that the deputy was also able to identify that there was one person in the car at the time of the fleeing and eluding, and she believed that the defendant matched the description of the person that she saw. Again, when the car was gone through after the fleeing and eluding incident ended, some of Mr. Coward's personal effects were in that car, identifying him as the person who was in the car.
So you're saying that the police officer did identify the defendant as the person fleeing? I believe, I just want to make sure we're all kind of on the same agreement. Obviously, there might be disagreement in the fact that what we have.
I think Mr. Harper and I disagree over how strong the identification is I think what he's saying.
That's fine, but he said he was not identified, and you got up and just said, police officer identified. I just want to make sure I understand. If you all disagree, it's fine, but I don't want to have representation here if the state's disagree.
What I'm going off of, Judge, is the probable cause affidavit for the first appearance paperwork, in which case that's, they're defining him as the defendant, exited the Nissan, ran south, was able to elude capture. Subsequently, Deputy Sheriff Carroll was searching the contents of the vehicle, noted some items that seemed to identify that Mr. Coward had some personal effects within the vehicle. As to an identification of Mr. Coward as the driver, we have not done Deputy Carroll's deposition yet, so that hasn't been, in my opinion, substantiated. But nothing in the probable cause affidavit seems to suggest that she identified Mr. Coward as the driver of the vehicle.
Okay. That's kind of what we're operating under, I think, the probable cause affidavit. Does the state disagree with the probable cause affidavit does not identify, does not have police officer or anybody else identifying the defendant as the...
Your Honor, I agree that that's what the probable cause affidavit says. Your Honor, he's, as a matter of course, not entitled to a bond on violation of probation. He is alleged to have caused damage to a fence and also jumped the fence with the car. That's how bad this fleeing and eluding incident was. He is alleged to have caused damage to a fence, and the narrative says that he actually jumped the fence with the car over an 8-foot, or he ran over an 8-foot privacy fence. I'm sorry, I read that incorrectly. But he is a habitual felony offender, and he scores 31 months in the Department of Corrections, so the state believes that no bond is appropriate in this case.
Well, if he's a habitual felony offender, that doesn't the court have to know on him?
No, Your Honor, that would be
that would be violent felony offender.
A special concern. And he does not meet that qualification, Judge. And again, if I may, I'm not certain if the state was done.
I'm done.
But again, I would reiterate that Mr. Coward was not arrested on scene. There was a warrant that was subsequently served on him at his, I believe, at his residence in Escambia County.
So what was the new law charge?
The new law is fleeing and eluding and a driving was suspended.
And what is the, what's the bond? What was the bond on the new charge?
On the new charge, Judge, I believe the new charge is $3,000 cash professional on the fleeing and eluding and an ROR on the driving was suspended, but he has no bonds on the VOPs.
Okay. I think we have to operate off the probable cause affidavit. The court will grant a bond of $3,000 on each of the violations of probation. Cash possession.
Thank you, Judge.
Gus Curley?
Could we get Mr. Noakes? You have your client here? He's only got one. Can we hold?
Yes.
So Mr. Noakes can get.
Yes, sir. I just stand right here.
Morning, Your Honor. I've got Salvador Bertrand, 23 CF 235. Judge, we passed this last time in hopes that he could put his hands on the money for the restitution. He's not been able to do that. I think the case will resolve itself and we'll just put it on another pretrial. He's tried to sell some stuff, probably got committed and people backed out. It's a
How much are we talking?
$225.
And you want to come back on a pre-trial or just come back on another miscellaneous in a month?
Miscellaneous is fine.
Okay, as long as we just come back, we'll come back on August 17th. Is that enough time? And I'll give you a little more time.
Would that be enough time, August 17th? Very
See you
good.
August 17th at 9 a.m.
Thank you, Judge.
Thank you. Have a good day.
You as well.
Gus Curley?
Judge, this is Gus Curley. He's before the court on 22 CF 1028, 22 CF 1532, 22 CF 1542, and 23 CF 557. Judge, I think the state and I have been in conversation. Additionally, we've received correspondence that he's been accepted into an inpatient treatment program, Project Hope. We're anticipating using that as a resolution to these cases. I think the state needs additional time to speak with the victim in the new law case, 23 CF 557. So we're going to ask to move this to the August pretrial.
Again, I'm going to ask you the question and not handle the answer, but can it be resolved
This victim lives
by the
in,
18th?
I believe this victim is out of state, Your Honor, so I'm gonna need a little more time.
So we'll come back on August 17th, that's the next day. August 17th at 9 a.m.
Could we put this on the pretrial if possible, Judge? Is that the 16th?
Sure. Sure, we can do it on August
16th or
16th.
16th.
16th. You keep that your paperwork. Keep talking about it.
Thank you, Your Honor.
Thank you.
God bless y'all. Thank you very much.
Cornelius Donaldson?
Judge Rudy Harper on behalf of Cornelius Donaldson, he's before the court on 22 CF 1617. Your Honor, if we may approach on this case.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is a
August 16th at 9 a.m.
William Hackett?
Judge Rudy Harper on behalf of William Hackett, before the court on 23 CF 183. This is a motion for bond reduction. Mr. Hackett's being held on a possession of paraphernalia, possession of controlled substance, and trafficking in fentanyl. The trafficking in fentanyl is $50,000 cash for professional. The bond as such is such that he's unable to secure his release. He's asking for a reduction of that particular bond amount. He was employed prior to this arrest. and he anticipates being able to resume employment with that same employer. He is asking for the court to reduce this bond to $25,000 cash and professional. It's our belief that the facts will bear out that this is a circumstantial possession case, even though there is there's an alleged trafficking amount, but we believe that's circumstantial. The hotel room in which these narcotics were allegedly found were not in his name. It was a room that was rented by another occupant, and he had not been in the residence or that room for any length of time. He just went in and out as law enforcement were observing. And I think that the personal effects of the occupant of the room were also associated with the narcotics. And so we're asking for a reduction of his bond in light of that, Judge.
The state is opposed. We believe that the bond being set at $50,000 is appropriate. Earlier this morning, there was a case heard where the court remarked that $20,000 bond on a fentanyl trafficking charge seemed a little low to this court. I would agree. I would also say that moving this down to $25,000 cash or professional is also too low. I think $50,000, which it's currently at, is too low. So for these reasons, Judge, the state's opposed. I believe that he's facing a 7-year min-man when the state proves its case in this circumstance. He has every reason to run, Judge, and for those reasons, I would ask the court to hold the bond at $50,000.
Where are we at as far as the discovery and just the pre-trial?
Judge, I think we're going to, I think this is the second time up, and I'm going to do depositions in this case. I think there has been some discussions with respect to a potential plea resolution, but we have not come to an agreement at this point. But there is some additional discovery that does need to be done, Judge.
I mean, obviously this is a substantial bond, but there are substantial charges, and the fentanyl trafficking is a serious, very serious charge, and I don't think it's out of line with the judge placed on the court. Doesn't see any reason to reduce it at this point. But I am urging everybody, let's move this case and let's try and get it to trial. If you believe it's circumstantial and it's not a warranted charge, we want to get these resolved.
Yes, sir. Thank you, Judge. I believe that's all I have today.
Judge, when do we set this case now?
I think it was otherwise already continued to the August pretrial.
That's where it'll be, but we'll confirm it's already
It's
August
August
16th.
Yes, sir.
We'll continue it, not continue, but next pre-trial will be August 16th.
And then to confirm the Tremaine Coward, I think that was already also set for August 16th. But if not, I would like to move it to that date.
Yes,
That was
sir.
another bond hearing. Okay.
Mr. Roberts.
Thank you, Judge. That's all I have.
Very good. Okay. Mr. Gates, you want to take a break, or you ready?
I will let Mr. Morrow handle the floor.
Tomorrow, you're
all of my...
because you're leaving us, doesn't mean you have to sit back in the gallery. You got to sit at the lawyer's table.
I'm just trying to stay out of their way as they're coming to Your Honor. I could call any of my in custody. I have one out of custody person I'll move.
Why don't you do those first?
We have
Hold on, let me get to your cases. Do you have any?
I have one, Your Honor. Mr. Aaron Jeffries.
Okay, Aaron Jeffries.
Ryan Marvel for Mr. Jeffries, Your Honor. This will be my first meeting with Mr. Jeffries. I'll ask the court to continue us either the 18th, to allow him to confer with me, and if we're already pretty backed up on the 18th, if that's not appropriate, we'll ask for the August date.
Has there been a plea entered in this violation?
I expect that the denial would have been entered at his arraignment, but if that hasn't been done, I'll enter a denial for the record now.
Okay.
I've been presented.
I think this is the first hearing. This is the hearing.
We'll enter a denial for the record, Your Honor. I've been made aware the state's offer is a DOC offer, so I'd like an opportunity to advise Mr. Jeffries of the case and the offer.
Is there an offer out there? We do have some space on the 18th if we want to try and get a resolution.
Yes, Judge, there is an offer. It is a DOC offer, so I've conveyed that to the.
You've conveyed that, okay.
He hasn't been very aware of the particulars of that, Your Honor.
Sure,
I was just presenting it.
but is July 18th sufficient?
That'd be fine. I'll have an opportunity to call me anytime this week, Your Honor.
Okay, so we'll continue this until July 18th at 9 a.m. In the meantime, make sure, get together with your attorney, okay, so we can figure out where we're going with this case.
Okay, now that's next week.
That's next week, yeah.
You ready for your image?
Yes, sir.
Jimmy Case. Case for the record.
Ryan Marvel from Mr. Jimmy Case, Your Honor. This is 22 CF 1820. If there's not already a denial on the record for Mr. Case, I'll enter that now. The state has presented their offer. They're seeking the imposition of a 30-month suspended sentence. Mr. Case is seeking admission to the Project Hope program. I anticipate this will be a plea straight up. This isn't a situation where I need a month to advise him on particulars of the court wants to put this on the 18th. I can meet with him again, talk about whether he'd like to plead to the court or resolve to what the state says.
Very good. We'll continue this until we'll enter the denial and come back on July 18th at 9 a.m.
Austin Clarkson.
You said 31. Sure. We're trying to around 40. Way better than we get about that. Counsel, do now.
Yes, Your Honor. This is Mr. Austin Clarkson. He has 3 matters before the court, 22 CF 550, 22 CF 2055, and 23 CF 760. This is going to be a negotiated plea on the VOP. The agreement of the parties contemplates asking the court to revoke and terminate the supervision, sent Mr. Clarkson to 8 months county jail with credit for all time served, all cases and counts concurrent, $100 VOP fee, $150 cost of defense, all financials to reduce to lien 1 year after his release. He will be adjudicated. PSI will not be required. I'll pause and give Mr. Clarkson an opportunity to sign.
Stated agreement.
Yes, Your Honor, that also states agreement.
And is the score sheet signed to Mr. Morrow?
No objection to the score sheet from the defense, Your Honor. May I approach?
You may. Thank you. Mr. Clarkson, would you please raise your right hand? I just need to ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
Okay, so you heard your attorney, put your hand out. You heard your attorney state the terms of your plea agreement. I see those same terms are contained in the written plea agreement you just signed. My first question is, did you read this plea agreement closely?
Yes, sir.
And did you go over it in detail with your attorney to make sure you had all your legal questions answered about this plea agreement?
Yes, sir.
And you understand, importantly, by entering into this plea agreement, as it's contained in here, you're waiving the right to go to a trial, force the state to prove their case. You're waiving all that so there can be a final resolution of this case today.
Yes,
Is that what you want to do? Is that what you believe is in your best interest?
Yes, and
Nobody threatened or coerced you or promised you anything other than what's contained in this agreement to get you to enter into this?
Yep.
You're satisfied with your representation? Question?
And there is credit for all time served.
That is correct. It's 8 months in the county jail. You get credit for all time, so there'll be 8 months on each of the charges because some of them are misdemeanors, some of them are felonies. But you'll get 8 months on each of them, but they'll run together. So that's called concurrent. So you have basically a total of 8 months, then you get credit for time served on each of the charges. They may be different or whatever, depending on the circumstances. Okay? Any other questions? Based upon that, the court will accept your plea agreement. The court will revoke and terminate supervision so you'll be finished with your probation. Sentence you to 8 months in the county jail. You get credit for all time served. Those 8 months are all cases, are 8 months, and they're all concurrent. They run at the same time. You've got the $100 VOP fee, $150 cost of defense. You'll have a year after you get out to pay those, or they go to a lien.
Okay.
Okay? Any questions?
No, sir.
Thank you.
I need to get fingerprints, any appellate rights?
You may. Sir, you do have a right to appeal this within 30 days if you wish to appeal this sentence I just made. Okay?
Sean Cloud.
Brian Morrow,
Did you
Mr.
give him a confirmation?
I'm sorry?
Did you give him a
It
confirmation?
says on there, it says 1 year.
When you
Yeah, it says 1 year after. You pronounce that Cloud? How do you pronounce it? Cloud?
Cloud, sir.
Cloud, okay.
This is 22 CF 1266 and 22 CF 1265. Your Honor, this is going to be a plea to the bench. The state had previously offered some guideline sentence. He'd like to be sentenced by the court. I'll pause and give Mr. opportunity to sign.
Is there an offer on the table?
Yes, Your Honor, the guideline says
What's the guideline?
15.15 months.
Clock? Sir, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay, so state's made up, you have the score sheet?
Yes.
No objection to score sheet, Judge Madro.
So you've reviewed the score sheet, Mr. How do you pronounce your last name?
Cloud, sir.
Cloud.
Yes, sir.
And it's 15.15 months. You're in jail, so you get credit for time served, right?
Obviously.
Yeah. So
Yes, sir.
I just want to make sure you understand. Well, the purpose of my question is two things. One, that you understand exactly what you're doing here, and that you're doing it freely and voluntarily. That's all the questions I'm about to ask you designed for those two reasons.
Yes, sir.
Okay? Because I know that the state's offering you the minimum guidelines. So you have to, I'm sure your attorney's gone over to go below this. Court's there's got to be proofs of downward departure and all that. Has he gone over all that with you?
Yes, sir.
But the maximum of this is 10 years. Do you understand? And the maximum sentence is 10 years. They're offering you 15 months, a little over a year. You got credit for time served, and you're at risk for 10 years. Has that been explained to you?
Yes, sir.
You're shaking your head a little bit. I wasn't quite sure. I mean, you want to send it to me, that's fine, but there it states, who knows what they're going to be asking for, and like I say, the maximum is 10 years. I just want to make sure you understand what you're at risk for because when you enter this plea to the bench, you don't like my sentence, you don't get a chance to say, whoa, I didn't realize that was going on. I'll take that other plea. You're pleading to the bench. There'll be a final resolution of this case, and then we're gonna argue about what the sentence is. Can be lower if they approve downward departure, could be the little over a year that the states offer, could be up to 10. So, you need to talk to your attorney anymore about this? I'm just asking. Counsel?
We'd like to proceed with the plea with Metro.
So, just want to make sure, I see you signed the plea agreement.
Yes, sir.
And heard you talking to your attorney. Just want to make sure you've gone over this, you read this closely.
Yes, sir.
And you're gone over it and had all your legal questions answered of your attorney.
Yes, sir.
You believe it's in your best interest to enter into this plea agreement.
Yes, sir.
And again, it's a little bit unique, this plea to the bench. It sounds cute, but what it means basically is you're agreeing that you'll be adjudicated guilty on this, right?
Yes, sir.
So that is the adjudication agreed to?
I believe he's already previously adjudicated on the
Okay.
underlying law.
So, you've got the two charges, the attempted burglary and burglary of an unoccupied dwelling, a structure. And so then you guys get to argue about sentencing. Okay, you understand that? And the state will be arguing based upon the score sheet, and whatever they perceive. And I assume that you'll be arguing for a downward departure.
Defense at this point, I don't want to say what I will and won't have
Well,
on today,
you've
but
got to be
as we stand,
you've got to be arguing for downward departure if you're asking for less than the minimum guideline, which he's already been offered. I just assume you're going to be arguing a downward departure.
sure, to be clear, Your Honor, he's asking to be reinstated and explain the circumstances surrounding his violation, which would require downward departure, as the court always has discretion to reinstate probation. Not necessarily that the court will,
That's
but,
good. That's good.
but that's the position, Your Honor.
Good. Okay. I appreciate it.
Yes, Your Honor.
Okay. So you're clear. You don't have any other questions of your attorney. I understand you are at risk for up to a 10-year sentence.
Yes, sir.
Very good. Based upon that, the court will accept your plea, and it'll be a plea to the bench. How long do you all need? We're going to do a PSI?
He has asked to be sentenced as soon as possible. To the extent that he's entitled to a PSI, the defense would waive it. But if the court needs one, or
And
the state-
I always like to look at them, and if you're looking at,
the defense will waive it to the extent that he's entitled.
I want.
I can't hear you.
Your Honor, it is a VOP and parole probation would have prepared the PSI. I'm assuming they're probably going to just adopt the recommendation currently of the VOP affidavit, so I don't know if it would be a waste of time if they're going to make the same recommendation.
So there's a VOP recommendation. What
On the
is,
violation report, yes, sir.
what is the recommendation?
I believe it's just the guidelines.
I believe that's the guidelines.
Okay. The only reason I wanted the PSI is just to make sure, look at the background and whatnot.
And usually,
It's got that contained on the report as well. So those are some of the things I'm looking at.
Yes, Your Honor.
Okay, very good.
And we
See,
can be prepared with the history. Your
Mr.
Honor.
Gates is trying to curry favor with probation so they don't have to do extra work. So, no, that's good. I want the information. How I get it is not a major concern. I'm actually not trying to double up your workload. You guys got plenty to do, monitoring all these things. Okay. So good, so the court will accept your plea, and we'll be a plea to the bench. When do we want to come back?
I have 2 in the afternoon on the 18th, Your Honor. I don't
Can't
know
do it
if that's-
on the 18th.
Okay.
In the afternoon, it's like you got 7. We'll do it on August 17th.
You've already got 7 cases scheduled.
On August 17th in the afternoon?
At 2:30, yes, sir.
What do we have on the 18th? I thought you said we had 7. Hold on.
Yes, sir, July 18th, you also have 7.
Okay. Well then, how about August 22nd?
Okay. Your August 27th, 22nd, you have 3.
Okay, let's do it August 22nd.
Okay.
Della Sala.
Counsel, would you?
Yes, Your Honor. Ryan Morrow for Mr. Matthew Della Sala. This is 22 CF 2646 and 22 CF 1777. This is going to be a negotiated plea on the VOP. The agreement of the parties contemplates that we'll be asking the court to revoke and terminate the supervision, sentence Mr. Della Sala to 9 months in the county jail with credit for all time served, all cases and counts concurrent. $100 VOP fee times 2, $150 cost of defense times 2, all financials to reduce to a lien 1 year after his release. He will be adjudicated. The pre-sentence report will not be required. I will pause and give my client an opportunity to sign.
State.
That's the state's agreement, Your Honor.
The defense. Okay with the score sheet?
No objection to the score sheet, Your Honor. May I approach?
You may. Mr. Della Sala, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? I do. So, you heard your attorney state the terms of your plea agreement, the 9 months on all charges. They'll all be served concurrent, you'll get credit for all time served. Is that what you are agreeing to?
Yes, sir.
I see that you signed the plea and sentencing agreement. Have you read this closely?
Yes, sir.
We've gone over it with your attorney in detail, make sure you had all your legal questions answered.
Absolutely.
You do understand this is a final resolution of your case.
Yes, sir.
You have a right to appeal it, you gotta do it within 30 days, okay? But, you've got, the sentence as imposed here is 9 months in the county jail. That's what you're agreeing to.
With credit for all time served.
With the credit for all time served.
Yes,
Very
sir.
good. Based upon that, the court will accept your plea agreement, revoke and terminate supervision, 9 months in county jail on all charges, credit for time served on all cases, and VOP and cost of defense financials reduced to a lien 1 year after release.
Thank you, Your Honor.
Thank you.
Your Honor, can we cut in and have
Sure.
the matter interpreter's case for the...
Sure.
Better Steve Medina with Brian A. Contreras Torres.
Hold on.
He's an add-on, Your Honor. You may not find him. We did a notice of an early plea late last week. We cleared it, so he may not be on the regular docket.
I don't have it.
Okay, would you repeat the name and the
Yes,
case
Your Honor.
number?
In case 23 CF 448, I have before the court Brian A. Contreras Torres. That's CONTRERAS Torres.
When was this filed, sir?
A notice of early plea would have been sometime late in the week, last week. We worked out his case, and I thought it was clear to add him to the docket to go ahead and.
I don't have anything.
And we also made arrangements for, appreciate the court reporter being here. I mean, the interpreter being here.
Do you have all the information?
I've got the case pulled up, I just don't see where you filed anything, so I'm just wondering if
It's always possible there was an oversight, or, you know, we certainly.
She's just addressing it procedurally, make sure that it gets in the proper place.
Thank you, Your Honor. I'm sorry, Madam Clerk. Your Honor, I believe Madam Interpreter was in another courtroom this morning and would not need to be resworn. But, Your Honor, at this time, Mr. Contreras Torres has a signed plea and sentence agreement for misdemeanors, if I may approach.
Okay.
And Madam Clerk, the agreement lists the lesser included offense statutes that are being pled out to in lieu of the information charges. Your Honor, under this agreement, Mr. Brian Andres Contreras Torres is being adjudicated guilty to lesser included offense simple battery. That's a first degree misdemeanor on count 1. It's actually the same level. It's a mint 1 as domestic violence battery, but it's technically a lesser included offense for simple battery. That's on count 1, and then more significantly, he would be adjudicated guilty to a lesser included offense simple assault, second degree misdemeanor on count 2, which is currently a third degree felony. There would be 11 months, 29 days probation on count 1 with 6 months concurrent probation on count 2. Probation to be supervised by Judicial Correction Services. Mr. Bailiff, Deputy Biden, do you have a card for JCS? And he will have to do the Batterer's intervention program, and he understands it's a very difficult program, so he's going to need to get started right away and really focus on that.
Available in the local area in Spanish?
I don't have an answer to that question, Judge. I know there are many, it does come up, but I don't have the answer to that question.
I don't think it makes much sense to order him to do something that he has no ability to do locally.
I have no reason to assume that it can't be done locally, because there are plenty of people in this situation, but I don't have that information. Does the state have any information? Your Honor,
I mean, you may know more about more people that doesn't.
Does state probation know the answer to that question? Is Batterer's intervention program available somehow locally in Spanish?
I believe that Patterson does Batterer's intervention program in Spanish, yes.
Great.
Thank you.
I didn't want to order him to do something that he had no capability to do.
Yes, Your Honor. I have an individual under my supervision who I refer to Patterson, who's a Spanish speaker.
Very good. Thank you.
And Your Honor, of course, understand what where the court was coming from. I also wanted to note that even though this is for lesser included offense simple battery, he's still having to do the Batterer's intervention program, and we're mindful of the court not preferring anger management in these situations. He will also be required to take no drugs except as prescribed, no alcohol, no firearms or weapons, Brandon urinalysis, and Madam Clerk, we have a blank for court costs. Can you tell us what the court costs are going to be?
These were down to a misdemeanor.
Yes, ma'am.
It's going to be the 622, the $270 in cost, then you've got the domestic violence trust fund for $201, and the assault fee for $151.
Your Honor, I inserted 622 in the blank. Do I need to do that on the original for the court?
Please. Thank you.
Thank you. So I'm just writing in 622. Okay?
Okay.
Thank you, Your Honor.
Thank you.
And last but not least, $150 public defender fees, or maybe it's least. And Your Honor, I needed to make a couple of final statements before the court considers whether to accept the plea. Number one is he's Venezuelan, and he would be subject to deportation, even though it's a significant lesser included offense reduction, especially on count 2. He still is technically subject to deportation. Number 2 is that he represents that he has consulted with an immigration lawyer and is very close to becoming documented. And he advises, I have not confirmed that this is okay with his immigration lawyers, and I have provided no independent advice on that subject.
Yeah, I appreciate you sharing that.
And I think it's an asylum situation from Venezuela.
State?
I'm so sorry. Was the simple assault still a felony?
No, simple assault is an M2. Did we not write it? I think you, I'm sorry, Madam Clerk, you don't see it, it's an M2.
I don't have it in front of, everything in front of me, so.
So it's a simple battery on count 1 and a simple assault on count 2, ma'am. Is that going to be the 622?
Yes, sir.
Thank you.
So, state's in agreement. I assume that there's a victim here that's been consulted. What's usually you would
Yes, Your Honor.
inform the court based upon downward departure, not downward departure, but a lesser included charge.
Yes, Your Honor, the victim wants a consultant.
And they're okay with that?
Yes.
Your Honor, if I may add, is that his wife had been wanting to drop the charges, and the state was not willing to do that without measures to protect the family.
Senor Contreras, would you raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay. You heard your attorney state the terms of your plea agreement. And I see those terms are contained in the written plea agreement that you've signed. Now, this written plea agreement is in English. Have you had it explained to you, or can you read, well, first of all, can you read English? Can you read this plea agreement and understand it?
I think it was dependent on the interpretation that was provided, the detailed interpretation. I'm sorry.
That's why I just need to ask you.
No.
What is his answer?
No.
No. So have you had this plea agreement explained to you in detail
Yes.
by your attorney?
Yes.
And so you understand that you are going to be placed on probation in both of these charges, even though they're lesser charges.
Yes, sir.
And as a condition of this plea, you must complete the Batterer's intervention program, which is about a 6-month program.
Yes, sir.
And you believe this is in your best interest to enter into this plea?
Yes, sir.
Okay. Very good. Based upon that testimony, and you understand this will be a final resolution of your case here today. The court will accept your plea. There'll be an adjudication of guilt to the two lesser included offenses of simple battery and simple assault. And you'll be sentenced to 11 months, 29 days. Probation is count 1, and 6 months concurrent probation is count 2. Probation will be supervised by JCS. You must complete the batterer's intervention program and not have any alcohol, firearms, etc. Court costs and fees are contained in the agreement as stated. And you heard your attorney state that you've got independent legal advice regarding anything involving deportation or risk of deportation as a result of these charges. Yes?
Yes, sir.
Okay. Do you have any other questions? Thank you. Thank you, Madam Interpreter.
Thank
We appreciate your help.
Thank you.
Thank you, Your Honor, and Madam Clerk, for sticking this in. Thank you.
Thank you.
Thank you.
Mr. Flannery?
Brian Morrow for Mr. Flannery, Your Honor. This is 20 CF 1030. This is going to be a negotiated plea. That's the BOP. The agreement of the parties contemplates that we ask the court to reinstate and modify Mr. Flannery's probation to include completion of the Keaton program. That'll be bars to beds as a component. All other terms and conditions will be reimposed. $100 VOP fee, $150 cost of defense. And defense is requesting the cost of supervision waived for Mr. Flannery's inpatient program. We're also asking the court to continue to withhold adjudication, and the pre-sentence report will not be required. I'll pause and give Mr. Flannery an opportunity to sign.
Mr. Morrow, talk very fast. At least talking to the microphone.
Yes, Your Honor. I'm coming from a division where you were not to say but even the middle initial if it wasted time, so
I understand.
I apologize.
One of the great challenges we have. Yes, sir.
Judge, as the defendant signs the agreement, I would point out to the court that he scores 41 points. I believe this is just a modification. Will the court require a score sheet?
May I approach? I think we'll need a score sheet for the file.
I mean, as best I understand, score sheet is required.
I'll give it to
I'm
you,
not trying to
Judge.
get unnecessary work, but I think we need to get that. Okay. Mr. Flannery, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
I do.
You heard your attorney state the terms of the plea agreement. Obviously, good plea agreement. You're basically reinstating and modifying. And the modification is the Keaton program, bars to beds. You go directly over it. Do you understand that?
Yes, I do.
All of the terms and conditions reimposed, fees, additional fees and costs that are required. You believe this is in your best interest?
Yes, I
To
do.
do this? And you understand there will be a final resolution of your violation of probation here today?
Yes, I do.
Very good. The court will accept your plea agreement, reinstate, modify to include completion of Keaton, bars to beds, the other terms and conditions that are contained here.
Thank
Good
you.
luck.
Mr. Giles?
By the way, Mr. Morrow, if you don't want to say the middle name, that's okay. Speed things up.
I'm just going to try to take it down to 20% of the speed, Your Honor, and lean into the mic. May I approach with the state before we call this case, Your Honor?
Sure.
Crestview's very own Dixie Dan Powell of Powell Injury Law. for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store.
That might lead to a resolution. This is Guy.
Thank you, Nora. Antonio Gray. Ryan Marlowe, Mr. Gray, Your Honor. This is 22 CF 564. May I have a moment, Mr. Gray? Your Honor, this is going to be a plea to the bench in 22 CF 564. I'll pause and give Mr. Gray an opportunity to sign. He's inquiring about the updated score sheet. I have not received an updated score sheet from the state in this case. I think that is something that he should be able to look at before we plea today. If the state has an updated score sheet today.
Do we have a score sheet? Give me one moment.
I do have the updated score sheet. He scores 39.2 points.
No objection to that.
What's is there an offer on?
The offer was 12.1 TOC.
And what's his maximum?
Across counts, it would be 21 years and 60 days.
Okay.
May I approach, Your Honor? Just sit back there.
Mr. Gray, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
What's the score sheet, what's the minimum?
Judge, he scores 39.2 points, so there is no lowest permissible guideline sentence. With that being said, the state's recommending 12.1 because we believe that's appropriate in this instance.
Okay. So, okay, so Mr. Gray, I see you've signed the plea and sentencing agreement. First thing, I want to make sure you understand that you read through this closely.
Yes, sir.
And you've gone over it in detail with your attorney, make sure you had all your legal questions answered.
Yes, I can question if you have a
No.
question.
Let me ask the question again.
Yes, sir.
I want to make sure that you have had an opportunity to talk with your attorney about this plea agreement.
Oh, yes, sir.
Make sure that you got all your legal questions answered by your attorney.
Oh, yes, sir.
I want to make sure you understand what you're doing here. Because you're taking, this is an important step.
Yes, sir.
Because this is a final resolution of this case. State's offering you 12.1.
Yes, sir.
The defense, I assume, you're gonna be arguing downward departure, less than that?
Similarly to the last gentleman, Your Honor, we asked him to be reinstated based on
Okay.
litigation.
But the maximum you're liable for is 21 years. You understand that you could be sentenced up to 21 years? Do you understand that?
Yes, Your Honor.
I just want to make sure you're aware of it.
Yes, Your Honor.
Are we ordering a PSI, or are we in the same situation where the affidavit will be essentially much the same information?
It would be essentially the same, Your Honor.
Okay, so you recommended the 12.1?
Yes, Your Honor.
And you understand by entering into this plea agreement, you're waiving the right to go to a hearing and to contest these charges. We're
Yes,
only
sir.
going to be arguing about the sentencing.
Yes, Your Honor.
And was there a previous adjudication of guilt?
I
It says
don't believe
discretion of the court, so that's
Right.
part of the plea?
No, Your Honor, there is no agreement, so, but he was not previously adjudicated, and
Okay,
that's
so
why
that would be part of
the
what
argument, yes.
the arguments. So why are you entering into this plea here today?
Yes, Your Honor, because I'm just ready to go ahead and get it over with and get back my family in. Yes, sir. Yes, Your Honor.
Well, but you could do that by accepting the state's plea offer as well. I'm trying to figure out why you're wanting the court to sentence you as opposed to taking that offer.
I can illuminate to an extent, Your Honor, if we need to.
No,
I understand.
I just want to make sure you understand what you're doing.
Yes, Your Honor. I just feel like prison just a little too steep for 39 points. You know, I don't even squad to go to prison, Your Honor. I'm just asking a little mercy from the court.
Okay. Okay. Very good. The court will accept your plea. It'll be a plea to the bench. The court will hear arguments regarding not only the sentencing, but also the adjudication of guilt. Please make sure and make a note of that and make sure that's argued and the court makes a ruling as it relates to that. That's a detail I may not be focused on, but it's an important detail for your client. Okay? When are we, come back on August 22nd in the afternoon for sentencing.
I'm sorry, Your Honor, what was that?
August 22nd, 2:30.
Andrew Keys.
Keys, Your Honor, this is,
Let's get to Ms. Hartford because she's female. I don't want to put her in there with them.
this is Andrew Keys, Your Honor, 23 CF 506. I've been presented with the state's offer this morning. It is a DOC offer. I'd ask that we continue this, and then when we come back, plead to the bench, or leave the state's offer. We're not anticipating a contested hearing at this time.
Are you going to be ready by next week, or do we come back?
I could come, if we want to bring it back on the 18th, I can advise on the state's offer, and then we can try and resolve it then, Your Honor.
Okay, so we'll continue this to July 18th in the morning.
No denial at this time.
And enter it now. Thank you, Madam
Yes,
Clerk.
thank you, Madam Clerk.
Maurice Warren.
This is Mr. Maurice Warren, Your Honor. 2007 CF 3181. At this time, the defense will request that we set this matter for a contested hearing, but ultimately, it's the hope of the defense and the parties that we find a way to resolve this with a negotiated plea or some other way, Your Honor.
Okay. How long do you anticipate contested hearing?
I anticipate, at this moment, I anticipate testimony from Mr. Warren, potentially testimony from his wife and son, and potentially testimony from his employer. So it may be a longer hearing, Your Honor.
Do we have the afternoon of August 24th? Off the top, it says at 1:30.
Yes, sir, you do have August 24th at 1:30, and your case is scheduled thus far.
August 24th at 1:30.
So this will be a DOT evidentiary?
That is correct.
Loretta Harper. Loretta Harper. Harper to the left.
Ryan Morrow from Misc, Your Honor, this is 20 CF 3087, 20 CF 3088, and 20 CF 3089. This is going to be a negotiated plea as VOP. The agreement of the parties contemplates that we'll be asking the court to reinstate and modify probation to include completion of the Saving Grace program. That'll be bars to beds. All of their terms and conditions will be reimposed. $100 VOP fee times 3, $150 cost of defense times 3. The defense is requesting that the cost of supervision be waived while the defendant is inpatient. She was previously adjudicated, Your Honor. The pre-sentence report should not be required. I'll pause and give Ms. Harper an opportunity to sign.
I have one clarification for you, too. Okay. What's the program?
Saving Grace.
Saving Grace, is that,
well-
is that a secure facility?
May I approach, Your Honor? I have
I'm familiar with actually.
Okay.
I'm relatively familiar, maybe I'm not. But when we do bars to bed, that's you know, bars to another secure facility. I don't believe Saving Grace is a secure facility.
It's described in the letter as a 12-month residential rehabilitation program with 24-hour supervision. So I don't know.
I'm sorry, Your Honor, I actually do not know the answer to that question. I've only had one other person.
All I'm trying to do is the right terminology when you bars to bed is transport to another secure facility. I'm not sure you're transporting that person to a secure facility.
I think
if it is, it's fine. I mean, I won't deny the program, even if it's not a secure facility. It's the beds to bars. I'm not sure that that's what we're doing here. But
from a defense perspective, I think it's more for the state's peace of mind that they're not going to be out on bond and they're not going directly to the facility.
How are they going to get to the facility?
I'll be calling the Saving Grace and letting them know that she's been court ordered. That for my part.
That would happen between Keaton. How do you transport to Keaton on a bars to bed?
I believe they are picked up by an individual from the Keaton program and transported to Keaton.
Is that a secure facility?
Keaton?
Yeah.
It's run by DOC. I would describe it as a secure facility.
So basically, a corrections officer comes and picks them up. Hey, look, as long as if everyone's comfortable, I'm okay with it. I mean, it isn't secure, but if she obviously runs, she's in violation of the probation, and I'm sure that's been explained.
For my part, Your Honor, what I will do when I leave court after someone's been court ordered to the program is I reach out to the liaison and then to let them know that they've been court ordered, they send someone to grab them. That's true for Phoenix House, Project Hope. I assume that it's true for Saving Grace. This will be my first experience.
My only question is the terminology bars to beds, whether that's appropriate for a not secure facility. But I'm okay with it if you all.
How I mean it, Your Honor, is that she's going to go directly from Okaloosa County Jail and go to that program.
Counsel?
Right. I'm less concerned about the terminology. My main concern is that she goes directly there. And my understanding was that they were going to come pick her up. Mr. Marr, is that correct?
That's my experience with all major residential programs.
No problem continuing this 1 week.
No.
So that way we can.
No, I don't think we need to do that.
Right. Of course,
I think we have clarified it in open court. We're on the record, and everybody's clear that she's not going to go visit her sister for a half a day on the way over there. That whatever. I'm being kind of just an example of something that's a direct pickup by Saving Grace to be brought over there. We want you to be successful, ma'am.
Yes,
This
sir.
is the best way to do that. Okay?
I understand.
We're not trying to put a roadblock. We're just the opposite. We want you to be successful, okay?
Yes, sir. I plan on being successful. I have no reason to fail.
I understand. Ma'am, would you raise your right hand? Do you have questions?
Judge, I just want to say on the record, just so that the defendant knows, this is a second chance and a big opportunity for her because she has a 5-year suspended sentence suspended right over her head. And I know this court makes a habit of telling all defendants that those suspended sentences are like a loaded gun and they can go off and they can really hurt you.
Okay, you got to be very careful when you use the judge's terminology. Again, you're right. I wouldn't normally use that terminology. I did use that. Be careful. But yeah, it is important to understand that I know your attorney is done. I just want to try and emphasize it again. If you're not motivated now,
Sir, I've had 2 sons in prison, and one of them is why I'm here now. And it is not, I do not want to fail.
And we want you to be successful.
I still, even though I'm in this predicament right here, I still want to prove to my sons that the right way is the only way.
Well, we're all on the same page, and you'll have an opportunity. It's a very good program. Saving Grace is one of the better, or not maybe the best. Certainly, it's a high quality program. There's very caring people that are there, and so it'll give you the very best chance. But it starts right here inside.
It's always here.
Well, now's the time. You're gonna get to prove to everybody.
Yes, sir.
Especially yourself.
Yes, sir.
and your children. Okay. Did I swear you in yet? I'm going to swear you in. You raise your right hand. Do you swear or affirm the information you're about to provide this court, the truth, nothing but the truth, so help you God?
Yes, I do.
You have the agreement?
I do. I'm just waiting for a signature.
Oh, you got to sign it. I'm sorry. I've been asking all the questions and didn't get her to sign.
May I approach, Your Honor?
You may. Thank you. So Ms. Harper, would you, just want to ask a few questions. Make sure you understand this. I see you just signed the plea, and it's called the plea agreement. Well, it's the plea agreement. You've signed the back. My first question, did you read this closely?
Yes, sir, I read it.
And did you go over it in detail with your attorney, make sure you understand?
Yes.
Okay. And obviously, there's tremendous accommodation on the part of the state on this, trying to give you a chance to resolve the drug addiction. Let's say call what it is.
Yes, it is.
And try and resolve this, so not only you can lead a better life, but also you can stay out of prison.
Absolutely, that's my goal.
Because that's suspended sentence, as counsel said. You know, that's the next step is, prison. And we want you to be successful. You're a part of our community too, and we'd rather you not spend it over at DOC. But it's up to you, because if you do come out of this second chance itself, probably you're going to end up getting sentenced. You understand that?
Yes, sir.
We hope that isn't the case, but the court will accept your plea agreement, reinstate and modify probation to include completion of the Saving Grace program and bars to beds, which basically means they're going to come pick you up, and no stops in between. And all terms and conditions, other terms and conditions are reimposed, and then you've got additional costs, and cost of supervision will be waived for the remainder of the probation. There will be an adjudication of guilt on all charges. Okay?
Yes, sir.
Good luck, man.
Thank you.
Did we get a portion?
No, Your Honor.
You're going to provide that?
I will provide.
Okay.
And appellate rights, right?
Thank you.
30 days to appeal.
Ma'am, even though I just sentenced you, you do have 30 days to appeal the sentence.
Yes, sir.
Talk to your attorney if you got any questions.
All right, thank you.
Mr. Marshall, approach.
I wrote down that the supervision fees are waived while in inpatient, but you're waiving them throughout the rest of the probation?
Yes.
Okay, thank you.
We'll do your max next.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boys Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
And then courthouse are gonna be 5:48, but you said 6:15?
5:15, I thought.
5:15, it's 5:48 on the calendar.
You just want to know the rest of
Put it on there tonight.
Probably not close out.
Yeah, this is Mr. Westbrook's before the court for a bond hearing. Go ahead.
You may proceed.
Yes, Your Honor. Mr. Westbrook is currently charged with arson. After speaking with his family, they're asking the court, Mr. Westbrook is asking the court to set a lower bond of $2,500 cash for professional with pre-trial services. It is their intent, the second they can get him, they will be taking him back to Pensacola and getting him enrolled in Lakeview for mental health and substance abuse treatment. They have an outstanding appointment, they just need to bring him there to make that appointment. Mr. Westbrook would like the opportunity to get started on mental health and substance abuse treatment. As far as the case and the charge before the court, I was able to review the discovery this morning, specifically what I was hoping would be video surveillance from the jail. It wasn't, it was actually body camera officers recording of the video surveillance, which made it a bit difficult, but what I could see was that Mr. Westbrook, along with the other co-defendant, Mr. Lee, were locked inside the cell at the time. Mr. Schaffner, who was outside the cells, appears to be the one that started the fire and was dealing with the fire. Obviously, video surveillance would be a little bit better for me so that I could see who was where, but at least on the video surveillance I've seen, it appears that Mr. Schaffner is the one that started the fire, was the one that actually maintained the fire and moved the garbage can to another area. How much Mr. Westbrook was involved in that, I don't know. I think the allegation is that he may have passed Mr. Schaffner a piece of paper. Again, Mr. Westbrook is adamant he had no knowledge of what was going on at the time. We were simply asking the court to take that into consideration and set a lower bond for Mr. Westbrook. I do know that his aunt is present in the courtroom as well. They've been very involved and would like to, like I said, get him out and to get him some treatment, which he has been on your needs, Your Honor.
Judge, the state's opposed to lowering the bond. I believe that the bond, as currently set, is appropriate. Judge, I would point out that the offer on the table is 10 years. It's based on his score. So, Judge, I believe it's a very serious crime. I think lowering it down to $2,500 is just not appropriate in this instance. So, for those reasons, Judge, I would ask you to leave the bond as is.
And if the court will allow me, I wanted to check two pieces of information.
And Judge, while Mr. Gates looks, I would just point out that if there are evidentiary issues with our case, the best way of resolving it is by working the case. And then if he has a motion that he wants to file, he's welcome to do so. But I don't think lowering the bond based on evidentiary arguments I don't think it's appropriate. This isn't the right thing.
And I would say that the court can consider anything before the court when determining a bond. As I said, I just wanted to check a couple pieces of information. I know that the state mentioned the offers 10 years to see based upon the score, but the score is actually like 92 months. So their score's here and they're going here. And it seems an awful lot based upon what I've seen on the video evidence of one person with the trash can outside of the cell doing everything and everyone else inside the cell. If that's the case, then everyone else in that cell block should also be charged with arson because essentially the same allegations could be said for them. The person who started the fire, controlled the fire, and even moved the garbage can has been charged, Mr. Schaffner. Mr. Westbrook.
How close are we to completing discovery and getting this thing ready for trial?
He hasn't even come up on his first pre-trial conference, Your Honor. I literally got discovery in this case this morning. And that's the only reason I was even able to tell the court what I was able to see on the body camera. Outside that, I would have just told the court what Mr. Westbrook has told me, but what he's told me matches up with what I've seen on video surveillance.
Judge, I'd like to correct something I said. He does score 92.4 months. So to Mr. Gates's point, he doesn't score 10 years. He scores some 7 years and some change. But the rest of my argument does remain.
state seen the video?
Judge, I have the video. I'm not sure if I've seen the specific video that Mr. Gates is referring to.
Point of interest here.
Yes, sir.
Maybe outside the box a little bit, maybe completely outside the box. Would it be appropriate to have the video shown and continue this motion hearing and have the video shown?
We would have no objection to that, Your Honor.
I mean, you know, I think the evidence is important. We're not having a mini trial.
No.
But, you know, right now, you're making an argument based on a video you've seen. The state's making an argument based on a probable cause affidavit and has not viewed that. I'm not saying you're obligated to, but I think if we want to look at, you know, we do have to look at each individual case.
Yes.
So I would ask at least one of two things. Either we bring it to the court, or at least have the state look at that to see. And again, I'm not asking you to stop the case, but I mean, at least address, you know. I mean, I would feel more comfortable. Look, I looked at that video too, and I think he was involved, Judge, and that's what the state's going to believe is their case.
Yes, sir.
I mean, that's a reasonable position to take. And I'm not saying your position is not reasonable now, but I'm just saying that, you know, you've raised a point. This is, if he's in a cell and not participating, or then it certainly brings it to bear. We can't bring these cases home quickly enough.
Yes, sir.
Does it make any sense to continue this for a week and at least look at the video and just reconvene in a week? I'm not suggesting that we bring it back and let the court look out. Just saying, well, have we ever done that? Evidence at a bond? Usually we just get up and argue, but I guess you could.
I think we have, Your Honor, situations when a case is a bit older. We've presented a bit of the evidence as well as testimony from some witnesses. So it's not unusual or unique. It's just for Mr. Westbrook, I know he was up for an answer today, but I think a week delayed wouldn't be an issue. My issue, of course, is I won't be here next Wednesday or next Tuesday. So
you will
not be here, Your Honor. So I would have to have Mr. Medina cover for me if he's open for that. No.
Judge, I have no objection to continuing this and then me reviewing the footage. And if we can't, I suspect we're going to have a disagreement about what the footage says, but we might bring it back to you on next week.
Okay, let's do that.
Thank you, Your Honor.
We'll come back in the morning. We still got a slot or two. We'll come back in the morning.
Yes, Your Honor. And that way I can actually go review that with Mr. Westbrook in the next couple of days and let him kind of narrate it for me as well.
Okay. And maybe you can get another video.
There it goes.
That's the hope, Your Honor. Yes, Your Honor.
There it goes.
Yeah, absolutely. Your Honor, this is Mr. Derek Jones before the court in 21 CF 2890 along with 23 CF 216. I have a plea agreement to be signed from Mr. Jones. He and I were going over the score sheet this morning, and he had a question. I wanted to make sure I got the answer before we entered the plea. Okay? Let me see if I managed to print a copy of that score sheet. What's the Mr. Gomes' copy, Your Honor?
May I approach, Your Honor?
No objection to the score sheet, Your Honor. That's going to be guideline sentence in Mr. Gomes' case.
Could you please announce the plea?
Yes, Your Honor. Mr. Gomes will be admitting the violations before the court in 21 CF 2890 and 23 CF 216. On the misdemeanor counts, it'll be time served. On the felony counts, we're going to revoke and terminate the supervision, sentenced to 17.7 months DOC, concurrent with credit for all time served, $100 cost of prosecution, $150 public penalty. Mr. Gomes has asked for 24 months from his date of release to pay those fees. And then specifically in 23 CF 216, revoke and terminate the supervision, 17.7 months DOC concurrent. That sentence will be coterminous with 21 CF 2980. Court cost, PD fee, and 24 months to pay those outstanding fees. Because it's coterminous with 21 CF 2980, the credit would be in 23 CF 216, the credit he gets in 21 CF 2890.
State.
That's correct, Your Honor.
Mr. Gomes, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your attorney state the terms of your plea agreement. I see, put your hand down. I see that those same terms are contained in the written plea agreement that you just signed, or that you have signed.
Yes, Your Honor.
Have you read this plea agreement closely?
I did, Your Honor.
And have you gone over it in detail with your attorney to make sure you got all your legal questions answered?
I have, Your Honor.
You understand that by entering this plea agreement, this will be a final resolution of your case. You're waiving the right to go to a trial, force the state to prove their case, all those legal rights you have. You're waiving those to get a final resolution of that.
Yes, Your Honor.
Is that what you want to do?
Yes, Your Honor.
Does anybody threaten or coerce you to get you to enter into this plea?
No, Your Honor.
You do understand there'll be an adjudication of guilt?
I do, Your Honor.
On 4 charges.
I do, Your Honor.
Very good. Based upon that testimony, the court will accept your plea agreement. The court will revoke and terminate probation in both counts and sentence you to 17.7 months DOC concurrent on both the felony charges. And the 23 CF 216 sentence will be coterminous with 21 CF 2980. You have the fees and costs. You have 24 months from the date of release to pay the outstanding costs, and the 2 misdemeanor VOPs, you will get credit for time served. Those will be resolved. Any questions?
No, Your Honor.
Thank you very much.
And the court, just for the record, can announce time served on misdemeanor counts.
That is correct. And you do have, even though I just sentenced you to this, you got 30 days to appeal.
Thank you, Your Honor.
Thank you. Ms. Ham.
Yes, Your Honor. Everett Ham. Your Honor, this is Mr. Ham before the court. We have a plea agreement to be filed in his case. If I can let him initial the change in the state's plea. They added a random analysis. They also put 180 days for restitution. It's my understanding the case law basically allows the court to reserve restitution for the entire term of supervision. whether or not there is a limited amount for that time frame. So let's just say that we need an amount for the 180 days, just an outside being reserved. May I approach?
I don't think it's binding. I think you're right. I think that
Ms. Leone was very good about providing that case law, Your Honor, on point, and it's very clear we can't limit the court's jurisdiction on restitution. Once the court orders it as part of the sentence, it has it for the jurisdiction of that sentence.
Judge, I would just say that he scores 27 points and this is not a downward departure.
Thank you. You're in agreement on the plea?
Yes, Your Honor, I am. And I'll get the score sheet to you.
Thank you.
Yes, Your Honor. Mr. Ham's going to be entering a plea non-contest as charged to both counts. It's going to be adjudication of guilt based on 48 months of probation concurrent between counts 1 and 2. As the court to waive the process of supervision, it says $515 in court costs, $150 defender fee, no trespassing at 544 Pocahontas Drive, Fort Walton Beach, Florida. No contact with both Mr. Logan Stuckman and Mr. Robert Flowers. Reserve over restitution to Mr. Logan Stuckman and Mr. Robert Flowers. Random urinalysis will be part of the plea agreement, Your Honor. And then I think Mr. Ham is going to ask that the court will allow him a one-time visit with law enforcement to pick up any property he may have still there.
That's impressive.
That's impressive. Okay.
4802.
So it's not there? Doesn't sound like the properties.
So it doesn't.
You don't need to go back then? There you are. It doesn't sound like we need to.
Mr. Hammond, you raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement. I see those same terms are contained in the written plea agreement that you've signed.
Yes,
Have you
sir.
read through this closely? You can put your hand up.
Yes, sir.
Have you read through this? You've read through this closely and you've gone over with your attorney in detail? Make sure you understand all the legal ins and outs. This will be a final resolution in this case. You're waiving the right to go to a trial. Do you understand all of this?
Yes, sir.
Believe it's in your best interest to enter into this?
Yep.
Yes?
Yes.
Do you have any further questions of your attorney about this plea agreement?
No, I guess I'll talk to the division.
Okay. Are you satisfied with your legal representation on this case?
Yes, sir.
Very good. Based upon that, there'll be an adjudication of guilt on both charges. The defendant will be sentenced to 48 months probation on each charge. They'll be concurrent. Got the fees and costs, and the no trespassing at the 544 Pocahontas Drive. No contact with Mr. Stuckman and Mr. Flowers, and reserve on restitution for those two gentlemen as well. And reservation just means that they may seek it. You would have the opportunity to have a lawyer and argue against it if you don't believe. I don't know if they are, but that's just kind of reserved. No, we're not dealing with that today. Okay? You understand that?
Yes, sir.
Do you have any questions you need to ask your attorney about that? And you are required to take random urinalysis. Do you understand through the term of the probation?
Yeah, no problem.
Okay. Make sure to stay in good contact with your probation officer.
I need your fingerprints, sir.
You do have the right to appeal this in the next 30 days, okay?
And the report by tomorrow morning, Your Honor?
How about today? Not today?
I'm not going to guarantee he's going to get out before after the day, and typically, if they're not released before 4 o'clock, they'd rather report by tomorrow morning.
Very good.
Yeah, this is Mr. Marcus Thompson before the court on a bond hearing in 22 CF 1938, 22 CF 2272.
Court has reviewed your motion. Anything you wish to add?
Yes, Your Honor. Mr. Thompson was picked up on 23 CF 1214, an allegation of driving a license suspended and possession of controlled substance. He and I have discussed that case a little bit. I don't have discovery, so I've only been able to review the pitch report, the arrest report PCF. Based upon my conversation with him, I think there may be some potential proof and identity issues. Obviously, I'd really like to look at the body camera. It's been my experience that not all PC affidavits are completely accurate. Sometimes there's portions missing, and I really would like to look at that in this case. But with that said, Mr. Thompson has been trying to get his driver's license reinstated. It has been something he's written several of the judges here locally about getting some of his costs pulled back for collections to allow him to make those payments. Obviously he was out on bond in these two cases. He'd been out on bond for roughly about a year. He'd been compliant with all those conditions. He's always maintained contact with my office. He's always appeared in court when he's had court and he can appear. He's open to the court setting either an ROR signature bond or a low cash bond with pretrial services, curfew, whatever the court would feel necessary if we need to have that as well. Mr. Thompson's main concern right now is his fiance and her children. She recently had heart surgery and has to have had a defibrillator put in. And so because he's not there to support, she's picking up extra hours trying to support the house and the 3 kids. And he really would like to get back out to try and help with that. If the court was to release him, he could go back to work tonight on one job and go back to work tomorrow on his other job. Obviously the school's starting here soon. He's concerned about being out to try and support and help with that as well, both financially and physically being in the house to help with those things.
Judge, I want to be clear about how this violation occurred. He was out on bond in this case, and what he's charged with in this case is case number 1938, fleeing and eluding with active lights and sirens, possessing cocaine, and then driving DWLSR habitually. He also was out on bond on a second case. In that case, he was smuggling contraband into a prison. He violated these 2 cases that are on the docket today by driving DWLSR with possession of drugs, and he did the exact same thing again when he was released. So as far as the state's concerned, he's not entitled to a bond. The bottom line is he's going to violate pretrial release conditions if he's released again today, is my position, by driving around Okaloosa County with drugs. It seems to be a pattern here, and I don't believe that he's entitled to a bond at this time. And he's saying that he wants to get out to help his family and everything, but last time I checked, we don't have very good public transportation in town, and I think he's going to have to be getting around town if he's going to plan on going to work and helping his family, especially if there's a medical issue in his family and no one else can drive him. So I'm just saying, I think if we release him, Judge, we're setting him up to do the exact same thing. And at this time, I think he needs to stay exactly where he is.
I'll try and argue some of that, Your Honor. I don't think there's any evidence or suggestion that he couldn't get a ride. I never actually said that. I think I said that he has been out over a year managing to successfully get to work, both jobs, and do what he needs to. This was the first time he's allegedly been picked up for driving. As I said, I think the body camera is going to be slightly different than what the police report says. As far as the other cases are concerned, Your Honor, now that the state's kind of opened that Pandora's box, I will address that. The first charge is a fleeing intent to elude. He and Mr. Thompson and I have discussed that at length, and unfortunately, as much as I would love to be able to challenge the legality of the fleeing eluding stop, the original stop, case law is not on my side. Case law says that if he flees and elude, he waives his right to challenge the legality of the stop. I would point out in that same case, the dissent says, what kind of constitutional right do we have if by being able to invoke it, I have to waive my right to challenge the legality of the stop? In other words, what kind of right is it if I waived it by not stopping, whereas if I stop, I waive my right to the constitutional right of free from illegal stops and search and seizures. And that's what I told Mr. Thompson. That's one of those that I don't mind arguing. We would lose, in my opinion, but I think it's definitely an appellate issue. As far as the drugs found in the vehicle, Your Honor, there was a passenger in said vehicle, Brittany Fain, who was also charged with possession of those same drugs. The drugs were not found on Mr. Thompson. They were found inside the vehicle. As far as the smuggling contraband charge, that was an arrest warrant based upon the fleeing and eluding charge. I would point out that in that case, Mr. Thompson was searched and frisked at least 3 times by 3 different officers prior to entering any sort of facility, and nothing was found. And it wasn't until apparently we get at the facility that suddenly something's found. I don't think there's any intent on Mr. Thompson's part to introduce contraband into the facility. It sounds more like they're at the worst.
What was supposed to be introduced? What was alleged to have been introduced?
That one I do have to leave back there, and it's methamphetamine. And I want to say it's a very, very small amount. But that's the reason those cases are a little older, Your Honor. It's taken time, unfortunately, to get all discovery. And in fact, in 22 CF 1938, I still don't actually have FDLE back on the substance found in the vehicle. It took me 2+ cycles to get an answer on the body camera from the original officer that it didn't work when she initiated the traffic stop. It didn't start working until after she had made contact with the passenger. It took me another 3 months for her to send us a PowerPoint justifying the stop in the first place. It's just been taking a very long time on this, Your Honor, and it's not through Mr. Thompson's fault. There really is issues with the evidence from the sheriff's office on this one. And during that time frame, as I said, Mr. Thompson's abided by all the conditions. Up until essentially here this last month, we had no issues with the violation, no issues with him driving, nothing. As I said, Your Honor, Mr. Thompson has significant ties to the community, has concerns about his loved ones, and is asking the court to consider reinstating a bond or setting a low bond on those so that he can get back out and do what he needs to do.
Yeah. Look, I'm always sympathetic toward family issues. However, there's a reason why people are not with their families, and generally caused by the individual and not by the state.
Yes, sir.
I'm not going to overcomplicate this. When you get charged with one crime and you're out, and there's a second crime or alleged, then you pick up a third charge, there's no basis for a bond to be issued, and we're not going to have a string in case people keep going out there and committing more crimes. So I'm not going to add to that. So I'm going to deny, based upon the fact that there are not one but 2 cases that are out there, and then another charge that was picked up. Of course, denying the imposition of the bond.
And that's all I have on the court's morning docket.
Thank you, Boyd. Jay Boyd is before the court in 21 CF 3019. I think he might be 31 on the docket. Your Honor, he is signing the agreement that we've been over. He has a copy that he's read through, and it's identical.
So you're not pursuing the bond?
Yes, I'm sorry. This is in lieu of the bond hearing, Your Honor. Okay. Worked his case out. I'm just finding my pen for him to sign. I have a copy for. We do need a score sheet.
Your Honor, this was an older case that was a habeas for a long time. I do have a score sheet that was previously done, but I had to print it out this morning, so when we take a break, I'll go get it.
And Your Honor, I'm just showing him what that score is. It's not changed from what was provided before.
I think it was 29 points.
29.6. We don't question the score sheet. May I approach, Your Honor? You may. Thank you, Your Honor. Your Honor, yes, Your Honor. The court will note that under this agreement, there would be withhold of adjudication as charged, and that's going to be on both counts 1 and 2. I had asked the state to consider dismissing count 2 in exchange for a plea on only count 1. The state was not willing to do that. I informed Mr. Boyd of that. And I also informed him that the state was not willing to do that today. And it may be that we could negotiate or litigate and he could get a better result, but he wants to go ahead and take the deal as it's before the court today. So there'd be withhold adjudication as charged on counts 1 and 2. There will be 2 years concurrent probation, but that's between counts 1 and 2, with automatic early termination upon full completion with no violations. $4,400, $4406.50 restitution.
So point of clarification, just so I understand this. The full completion with no violations means payment of the restitution and the communities, what does that include?
That means all requirements that are specifically set forth in here, and then no violations of any requirements, including the general conditions of probation. So for instance, the specific things that have to be affirmatively accomplished would be the payment of restitution, of course, no trespass at any T-Mobile
So
location.
let me just give you a hypothetical, just so it'll clarify for me. He does all this stuff in the next 30 days, can he terminate? Would it automatically terminate, or is there some?
There's no minimum period, so it does fully incentivize payment of the restitution in full.
Yes, that is correct, Your Honor. Also with his cost of supervision, he'll need to be current on that to that month, and then he could early terminate. Right.
Okay, good. Just wanted to clarify.
Thank you, Your Honor. Appreciate the court doing that. So just to complete the specific terms, no trespassing at any T-Mobile location, no contact with Nader, Gabriel, and Miss Madam Clerk, that's spelled in the agreement, thank goodness. 50 hours community service, no disrespect intended. Anti-theft class, 515 court costs, 150 PD fees, and the state agrees not to file charge on FTA.
That's the agreement.
Thank you. Mr. Boyd, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
So you heard your attorney state the terms of the plea agreement. I see those same terms are contained in your written plea agreement that you've signed. First question, did you read this closely?
Yes, sir.
And did you go over it in detail with your attorney, make sure you had all your legal questions answered about this plea?
Yes, sir.
And importantly, you understand this will be a final resolution of this case. You're waiving the right to go to a trial, force the state to prove their case, all those things in order to get a final resolution. Is that what you want to do here today?
Yes, sir.
We talked a little bit about, exactly what these terms mean, because sometimes they're not, we just want, well, let me phrase this way. We want you to be clear about what your obligations are and what the benefits are as far as, early termination. So you're clear about all that, you heard that discussion, you're clear what you need to do to early terminate?
Yes, sir.
That includes everything, importantly, the restitution, but also the cost of supervision, the court costs, etc.
Yes, sir.
You understand all that? Very good. Any questions regarding any of this?
No, sir.
Okay. And there will be a withhold of adjudication, so based upon that testimony, the court will accept your plea, withhold of adjudication on both counts. You'll be sentenced to 2 years probation. For each count, they will be served concurrent with each other with an automatic early termination upon full completion of all the terms of the probation with no violations. And some of these terms are as contained, well, all of them that are contained in this plea agreement, but importantly, you got the 4406 in restitution, and then the community service hours and the court costs. You also will not be charged, so the state will not charge you on the failure to appear.
I just wanted to put one thing on the record that I advised Mr. Boyd, because he represented to me, he also had the county probation term, and he's been advised that he might want to go see if the county judge would allow those terms and conditions to be transferred over, so he only has to do one probation, but there are no assurances that would be granted, and so basically until otherwise determined or ordered by the court, he's going to be
Those
doing
are
2
separate.
probations.
Keep those kind of in your mind separately unless somebody formally ties them together.
Thank you, Your Honor.
Question?
Thank you. And I think he lives in Crestview, is that correct? So you have to report at 13 Kelly Avenue in Fort Walton Beach. So for the initial reporting, and then they'll work on where you reside, moving to probation. Thank you.
Thank you.
Last minute is Clifford Duck for this morning. Your Honor, Mr. Dove is before the court on a bond motion. We are going to go forward with that bond motion. It's in 23 CF 1255. I think that he is also on the 130 docket for arraignment. I will advise the court that the state has tendered an 1129 jail offer, which he doesn't wish to accept, and we're not going to be able to work out the case today. We can go ahead and waive arraignment and enter a not guilty plea so that he doesn't have to be held over to 130 if that's okay with the court. This is Clifford L. Dove before the court in 23 CF 1255.
And you're entering a not guilty plea in that case?
Yes, Your Honor, so he doesn't have to be held over to 130.
Court will enter the not guilty plea in the 23 CF 1255.
And then if we may proceed with the motion for bond reduction, Your Honor.
Did they get an information filed in the new
That's a good
charge?
question.
I checked yesterday and I didn't have one.
There should be one, I'll check right now.
Good, please, thank you very much.
We did file some on that.
Okay, that's good. Never mind the other.
Your Honor, he's been incarcerated since June 4, 2023. There is a present bail of $1,000. He's requesting a $1,000 signature bond. He represents that he's self-employed. He's lived in this area for 12 years. He has an 8-year-old child. I think if the state and the court will consider the probable cause statement, it's frankly, it's pretty sad. He knows not to talk about the facts, but there was an alleged stealing of a $2 box of crackers, allegedly from a place that everybody in Fort Walton Beach holds near and dear. I know that's the rec center over on Hollywood, but I'm asking the court to please give him a signature bond and allow him to come to court. He could be required to comply with pretrial services if the court would determine that would be appropriate, to make sure he does comply with the law while he's out. But because of the nature of the crime, the alleged crime, the bond was set low at $1,000, but to a homeless person, $1,000, even $100 to a bondsman can be prohibitive, and that is the situation here, Your Honor. We're asking for a signature bond.
State?
So, yes, Your Honor, the state is opposed to reducing the bond. I think the bond is extremely appropriate. $1,000 cash professional is, as Mr. Medina has stated, a low bond. I understand.
Did Mr. Medina state properly the allegations? I have not looked at the probable cause. I just wanted to confirm that the state doesn't have a different view on it.
So, yes, Your Honor, he was found inside the rec center in hours when it is closed. He was found by some employees upon them returning to work in the morning. Then it was discovered that he had taken some food items while inside the rec center. So that's where the burglary.
Court granted the $1,000 signature.
Thank you, Your Honor. Your Honor, may he remain on, he's probably could be on the August 14 docket for pretrial.
Yes, sir, that's where we currently have him.
We'll be on the August 14th pretrial, 9 a.m. Make sure and stay in touch with your attorney so you can deal with this, okay?
Thank you, Your Honor. What's your name again? Chad Carter. He's unrepresented, please. Yes, of course, today he's on the docket, but I don't know which time.
I've got it.
Judge, may I excuse you?
You can come forward, sir. Go ahead. I've got something that a motion to continue was filed. I made a note of that in my prep. Yes, sir.
Here,
Oh, you've got, yes, I know.
I believe that this is Chadwick Carter's, who is going to be listed on this afternoon's docket. I think the case number
Okay,
is.
so that's not the Carter on this morning's docket.
Is that
Jamal Carter.
So does he have is he on the afternoon docket?
Yes, I believe so.
Do you want him to come back at 1:30, Your Honor?
Yeah. Let's see.
And I am showing him listed as a no attorney charged with aggravated assault.
Okay. So, Mr. Carter, you do have a right to have an attorney appointed in this matter? You wish to have an attorney appointed?
Yes, sir.
Court's going to appoint the public defender. You got to fill out that form. I'm going to enter a not guilty plea on your behalf.
Yes, sir.
So that will preserve your rights until you talk to your attorney and figure out where this case is going. You do not have to come back this afternoon. Your next court hearing is the pretrial, which will be on August 14th at 9 a.m.
14th, 9 a.m.
9 a.m., not 1:30.
Yes,
This
sir.
one was scheduled for not 1:30 this afternoon. That's
Oh, okay.
anyway. But you don't have to come back at 1:30. We just dealt with it.
Thank you.
Any questions?
No, sir.
You got the contact information for your attorney?
August 14, 9 a.m. is your next court date, and that's my assistant's name to call that number, et cetera. Make sure you fill out the application completely before you leave.
So, just for,
I feel the hell out of the jail.
on Carter, Jamal Carter,
Yes, sir.
whose case is that?
This is my question.
There was a motion to continue. I didn't really get much explanation about what the motion is, and there was an attorney, and I guess she thought also that by filing, that's automatic.
So I can fill the court in. So we were hoping that we would have a resolution. There is something that we're going to need to talk to an investigator about, namely nailing down what the anti-theft device is, which is the felony charge in this account. So we are going to attempt to resolve that before the next pretrial. Ms. Harris should have put in the motion that we were attempting to resolve that, but it can't be resolved at this court date. Her client was driving from Miami. She called several times to the office yesterday wondering if I had seen an order you'd sign an order to continue. I informed her that the power was out, and I did not know if Ms. Van Boxel was even still at the courthouse for her to inform Your Honor of that motion.
We'll continue this matter until August 14th at 9 a.m.
And I'll let Ms.
But
Harris know.
when, she just didn't know, she's not.
She doesn't know.
You've got to actually explain if you want me to sign a continuance without, yes, let us know, or we'll just come to court and figure out how to continue. Okay, so 1:30.
Yes, sir.
I think that's all for this morning, isn't it? Thank you all for your assistance.